In a divorce matter, one party can sometimes claim spousal maintenance against the other party. This is usually in a case, for example, where there has been one primary breadwinner and the other party has been unemployed during the course of the marriage. In the middle of the divorce proceedings and on the court papers, the party who was supported during the course of the marriage can ask for so-called rehabilitative maintenance or lifelong maintenance from the other party. So this can never be a situation where, for example, a man has supported a lady for 20 or 30 years and all of a sudden wants to walk out of the marriage and leave the lady destitute. There would be an obligation on him to support her post-divorce. Rehabilitative maintenance is maintenance which has to be paid for a shorter duration of time. For example, 2 or 3 or 4,000 or 5,000 rand for 6 months after the divorce, or a year after the divorce, or 2 or 3 years after the divorce. This usually happens if the parties have been married for only a few years and the one party has supported the other. If the parties have been married for 20 or 30 years, then very often there is a claim for lifelong maintenance. In order to work out the maintenance, the courts look at what each party earns and what the reasonable expenses of the one party are. They look at the monthly expenses in order to determine the maintenance. The expenses must obviously be reasonable. The court would look at what it would cost for, say, for example, the wife to find accommodation elsewhere, what a rent would cost, what her monthly groceries are. Exactly how maintenance is calculated in respect of minor children, so is maintenance calculated in the case of a spouse. If you can prove that your spouse got you accustomed to an extravagant standard of living, then there would no doubt be a legal duty on that spouse to maintain that person in the same way as they got him or her accustomed during the course of the marriage. Very often a divorce is prolonged because of the spousal maintenance issue. Sometimes there's one spouse who believes that they are entitled to maintenance from the other spouse and they are unable to settle this matter outside court, and eventually the court has to decide on the amount of maintenance, if any, that must be paid. So if you get somebody accustomed to a certain standard of living, you have to realize that if you do get divorced, there is going to be a duty on you to maintain that person afterwards. You can never just walk out and leave that person destitute or without money. The Rule 43 application is an application for interim maintenance and a contribution towards legal fees. That Rule 43 can include a claim for spousal maintenance. Sometimes there are no minor children born of the marriage, but the Rule 43 is launched for the one spouse to get maintenance from the other spouse. You're never entitled to cuts. If you keep your spouse on a medical aid, for example, you cannot simply cut that spouse off the medical aid, because there is a risk there that that person will launch a Rule 43 application against you. Just like with maintenance for the minor child, with spousal maintenance, the one spouse is also entitled to approach the local regional court, maintenance court there, to get maintenance. It works in exactly the same way as with minor children. This obviously also depends on the affordability of each party. Not everybody can afford to launch the Rule 43 application in the High Court, and sometimes they just go to the maintenance court and try and sort it out there. The difference between the Rule 43, however, and the maintenance court is that the Rule 43 is decided on the court papers. There are very seldom postponements in a Rule 43. A court date is given and the judge listens to both parties arguing and the judge makes an order for maintenance. The maintenance court, however, very often postpones a matter where a party doesn't have bank statements, for example, or tax returns, or whatever the case may be. It is far quicker to get a maintenance order in the Rule 43 in the High Court. That is all I have to say on spousal maintenance at the moment.